constitutional lawyer Paul Kumi. Mr. Kumi, good evening to you. Always a pleasure having you on this program. We started with you when a convincent Asefa filed his first injunction application, and then the second one today they were in court. You said that following from what the president had done, the injunction application seeking to stay the hand of the president was moot. But today it looks like two of the justices of the Superior Court disagree. They say that the 3-2 ruling said that legally the application was meritorious, it had merit, and it was not dead on arrival.
Well, this is what makes law practice very interesting. So that whilst I am saying that the bottle is half full, somebody else says it is half empty. And of course, various arguments are advanced to justify whether or not the arguments made can stand the test of time. Indeed, I did even hear the Member of Parliament and his lawyer saying that they were waiting on the various reasoning. What will have informed the stance as taken by the justices of the Supreme Court. So when those reasoning come, we will all look at them, and then we should also be able to tell whether or not their interpretation of the law is in the right direction. Incidentally, people are now almost always trying to use the expression purposive, and they are making the word purposive assume a certain magical dimension, which means that because something is supposed to be purposive, even where everything is quite clear and does not need any further interpretation or doesn't require any further explanation, we will have to be doing that. It's like building a bridge on a flat road. It looks like that is how some of our colleague lawyers want this to come about. The issue of a prima facie matter has been clear for all these years as practitioners. Indeed, the concept of prima facie is that you look at the issue and on the face of it, you come to a certain conclusion. But that is a rebuttable conclusion. What it means is that I think there might be some truth in what is being said. So let me give to the other party against whom the accusations might have been made to come and state a side by way of rebuttal to what it is that has been said against that person. So when people now are beginning to adduce other meaning and claiming that the issue of
prima facie
will have to be determined, and a whole lot of them. I have said on various networking that when the suspended chief justice says that what he used to do was that when persons were referred to her for her to make a determination of a prima facie matter, she used to call those persons, ask them for their version before she came to the conclusion that there was a prima facie matter against them or not. If you did that, you were virtually making a judgment in respect of what has been said. And so we cannot use a practice which I see to be flawed as the basis upon which we will now have to make a determination of a prima facie matter. And so, fortunately for us, the justices will come out with their reason. And we will read. And of course, law is a living entity. It grows. So if what they say is something which we think can help us in the growth of our jurisprudence, why not? We will not want to be failed. We will not want to be eaten over by time. We will adopt them. But definitely, they will come and it doesn't sound good. We as lawyers also have our day. And we will critique whatever will have been said by them. And then we'll go ahead and take a look at this. But you will realize that nowhere
Mm-hmm.
is it that Asafua and the lawyer are even criticizing the constitution as established.
Mm.
What they are talking about
They
is the
rely
fact that,
on the 2-4 versus Attorney General and J. Trum case.
yes, in respect of that one, there were various arguments that were made. But even in that specific matter, that the bar did indicate that when one took a look at the draft constitution, the draft constitution had made provision for a prima facie matter to be established.
Mm-hmm.
So to him, he thought that the absence of that provision in Article 146 possibly must have been an oversight.
Okay.
And so it makes sense if that thing is brought in, because he went back to look at the draft, and in the draft there was that provision.
Mm-hmm.
And so obviously it will be presumed that in the final drafting of the constitution there must have been that inadvertence where that thing was left out. So it makes sense for him to say, okay, in any case, the lady also happens to be a lawyer of the Superior Court.
Mm-hmm.
And so why don't you let her also enjoy same privileges as enjoyed by lawyers of the Superior Court?
Mm-hmm.
And that makes sense. I hope you understand what I'm saying.
Yes, I do.
Now, but what we are saying, because you look at this whole concept, where the Chief Justice, because if you look at Vincent Asafua, he started on the note that he felt that until the Chief Justice was furnished with the petition, and for her to
respond, yes,
response,
the president had to hold on, or the process for even sending it to the Council of State was illegal, or he had the right of the Chief Justice.
Those were the things he was saying initially.
Yes.
Right?
That was the first application that was withdrawn.
That was the first application. Now, it was followed by a letter from the Chief Justice herself, virtually re-echoing the very issues that had been raised by the Supreme Court. The president obliged her, gave her the petition, gave her a timeline, and within which timeline, the Chief Justice also furnished her what? Her responses. And so, what Asafua had said earlier that they ought to do before the committee could be set up had been done. And that is the reason for which some of us say that this whole thing was missed. But you realize that just after the president had accorded to the Chief Justice her request, and the Chief Justice had also provided her answers, then you realize that there is some kind of mutation.
To the
things were now beginning to change as regards the original stance that Asafua had. I hope you understand what I'm saying.
Yes.
And that's where you begin to read other intentions. So it is therefore not the case where what you are looking for is for the proper or the fair interpretation or effectuation of the Constitution. It looks like you are playing some games. Now take another look. Before this letter or before these petitions were given out to the Chief Justice for her comments and whatnot, did anybody have any idea which people were the authors of the third petition?
No.
Do we know the content?
No, we didn't.
But just after the Chief Justice had been furnished these copies and she has furnished responses, now this thing is almost all over. And to the extent that we have even the chairman of the Ghana Bar Association now saying that don't let us do things in camera as espoused by the Constitution.
That we should
and
do
that
a public
if it is the will or if it is the pleasure of the Chief Justice, this thing should be done in public.
Just like what the NPP and the minority are asking for.
Precisely. How can one say that? Because the Constitution is clear that the whole thing must be done in camera. There is nowhere where it is indicated that the one against whom the accusation had been made can elect that it should either be in camera or it should be in public. But here we are with people now coming out to make these submissions. And it doesn't look good. You see?
And these are the people who say they are fighting for democracy and upholding the Constitution.
No comment.
Why don't you want to comment?
Leave me not in confusion.
Can't continue.
So, at times some of us get a bit worried with some of these Janus faced attitude. In one breath you say this, in another breath you are saying something different. You understand me? So we are virtually taking over the judiciary, the independence of the judiciary is now virtually being compromised, and a whole lot of them. So Ghanaians should not allow this thing to go on. So where were Ghanaians, these apostles of democracy and whatnot, where were they when persons who were doing their work, the Domelebos and others, just for the simple reason of being insistent that certain things had not been done right, and so they should be so seen to be done, they were asked to go and take the accumulated leave. I hope you understand what I'm saying.
Yes, I do.
The matter was brought before the Supreme Court by certain concerned Ghanaians. It remained there for ages. At the time that the Supreme Court took notice and came out with its judgment, it was just for academic purposes. The man had hit retirement, and so he couldn't come back to work. But here we are. We see a situation where on a particular day, where we know that the Supreme Court doesn't set, applications are filed, and by an hour or two, we have a whole, jury and panel, and for them, we have a whole panel put in place, and for them to come and make a determination on the matter. So you see, some of these things, they are very obvious, but you have to be very careful. You don't have to be saying to be commenting on them.
Okay.
But I believe that in this particular instance, what I keep telling people is that it is not as if we are seeing a situation where judges are being removed from offices, or judges have been so petrified they are even unable to say any particular thing. You remember some time ago, when at the very last minute there had been a particular panel put in place to hear a particular matter. Just at the last minute, the panel was changed. Right?
Yes.
Dami Godfrey was, what's the name? He was the AG at the time.
The Attorney General.
He didn't find anything wrong with it.
No.
Today he's raising issues because of the rape.
No, because they say that the acting CJ is the ultimate beneficiary.
There's no beneficiary thing here. What benefit is he going to make?
Because in throwing out the application and others, if the CJ is removed, he automatically assumes the position of the CJ.
No.
And they cite several cases that the CJ is not supposed to sit. And again, to them, even based on the ruling that came out, the empaneling or repaneling, the three people that were against the injunction are the people that they didn't want as part of the justices who sat in this case.
So they were okay with Gayu, because Gayu had been an NPP candidate who was possibly at the High Court and was pushed off step and jump and sent to the Supreme Court. So they were comfortable with him. Is that the case? I hope you understand what I'm saying.
Yes.
Now, let us understand that in being appointed as the Supreme, as the Chief Justice, does not solely lie on seniority. The only time the seniority comes up is when a panel is set up. So then the most senior naturally becomes the president
of the panel.
Or in the event of the Chief Justice being outside of the jurisdiction or being sick, the one who is going to act in that CJ's absence will be the most senior.
Okay.
But when it comes to the appointment of a CJ, Mahoney had been at the Supreme Court as far back as 2008, appointed by President Kufuor. And we had the present CJ appointed in 2019. But she was made a CJ. Did anybody fault it? Because when it comes to the appointment of a Chief Justice, the law is silent. It says that it is the President who will have to do the nomination in consultation with the Council of State. Right? Then voting at Parliament and a whole lot of them. Once the person gets the nod of Parliament, he will then be sworn in as the Chief Justice. So he does not wish to say that because he's now the acting CJ, it passes that if there should be anything against the CJ, it will inure to his benefit. If it were to be the case that by our system, the most senior automatically becomes the CJ when the how do you call it, the CJ who is in place leaves the office, right? Then you could make the argument that okay, this man is taking up the acting role, and he knows that when the present CJ, the suspended CJ, goes away, he will be the one who benefits from such a move. Okay. But there's no such clear cut. It could happen that neither he nor Paman, who are the most seniors, at least currently. No, I mean you even look at the appointment of the Court of Appeal judges who have now been moved to the Supreme Court. It is only the first 5 or so who happens to be among the first 10. But 2 of them, they were either the 23rd or the 24th. Meanwhile, we have 48 Court of Appeal judges. So it doesn't always watch that it is the most senior who will go or that the most junior will remain as where they are. Okay. So I didn't see how those arguments were coming. But of course, as lawyers, we have very, very fertile brains and we can really think, I mean, twice on our feet and make very, very wonderful remarks and suggestions. So I don't fault them. I believe that they have fought a very good fight. But of course, the law has spoken. Okay. And I will want to still always re-echo what the Chief Justice once said. The law is the law, no matter your noise making.
Well, we will see. This matter is not going away anytime soon. And then we will read the ruling on 21st May, and definitely, I'm sure, we'll get back to you. Counsel,
very well.
Very grateful for your time. Paul Kumi is a constitutional lawyer.